First case for oral argument this morning is Wilmot Shaw versus Psychomedics Corp. Counsel, prepare to go forward. All right.
Good morning, Your Honor. May it please the court. I'm Aaron Wallace. I'm a lawyer at the Gist Law Firm here in Columbia. Seated to my left is Mr. Donald Gist. We're here today on behalf of the plaintiff in this case, Mr. Wilmot Shaw. The facts in this case, essentially, and how we got here, they revolve around Mr. Shaw's termination from employment with BMW as a result of a false positive drug test, which was performed by the defendant, Psychomedics. We filed the suit in March of 17. It was removed by the defendant. The federal court, and a motion to dismiss was filed in June of 2017, which was heard by Judge Timothy Kane in November. And the certified question which followed as a result of that motion to dismiss hearing was, or is, under South Carolina law, there's a drug testing laboratory that has a contract with an employer to conduct and evaluate drug tests or a duty of care for the employees who are subject to the testing so as to give rise to a cause of action for negligence for failure to properly and accurately perform the test and report the results. Just very briefly, some of the facts which lead up to this, because they have some importance here. Mr. Shaw, long-term employee of BMW, over 14 years employment with BMW.
How often had he had these periodic drug tests in the past?
During the course of his career there over the 14 years, the way that they assigned the drug test was randomly and periodic. I couldn't give you an exact number, but it was on several.
But he'd had them before.
He had them before. History of no drug use, positive employee. BMW.
Cut to the chase and find out, and you tell us what is the basis of the duty in this case?
The basis of the duty, Your Honor, we believe goes directly to the relationship between Psychomedics and the general public really the employees. If you look at the case, one of the things that the defendant raises is this issue of privity of contract. They harp on this issue of privity of contract.
But that's not required, is it?
It's not required. And as was basically indicated in several cases in this state, Durrell versus South Carolina Department of Transportation, Terlin versus Neely, Edwards of Burns Downs versus Charleston Sheet Metal, this court has actually found very specifically that privity is not a bar when you're dealing with negligence actions to a duty being owed.
Well, how do you reconcile Charleston Dry Cleaners?
Reconcile Charleston Dry Cleaners very succinctly here. Charleston Dry Cleaners dealt primarily with this insurance relationship. If you look at the actual holding of that case, the plaintiff in that case had an out. The plaintiff in that case could rely on bringing a first-party action under the rules of agency.
And you don't have that here, do you? There's nobody else your client can sue about this, is there?
That's correct.
Certainly can't sue BMW because
that's correct.
It will employ.
That's correct. You can't bring, unlike in Charleston, you can't bring a first-party action and rely on respondeat superior to get some sort of relief. In our case, our client is essentially out in the cold as a result of these negligent drug testing. Since, the duty issue is not really not going to be determined by privity. Yes, Your Honor.
Thank you, Ms. Wallace. A lot of times when we get these certified questions, they're sort of in a different posture than an ordinary appeal because the facts are really not completely settled. We don't have a complete record. And if it's in the little bit of the record we received, I couldn't find it. Perhaps I missed it. Are the facts at all important? I couldn't discern to a certainty who collected the sample. I couldn't discern if the negligence was in the collection, was it in the transmitting of the collection, was it in the testing itself, and maybe those questions and the answers to them don't make a difference. I'd like for you to respond to that.
Yes, Your Honor. And this is where I think it's a distinction without a difference. I do. But with respect to the facts, it's a motion to dismiss that was being made, and our allegations are that the defendant was involved in the collection process, not only in the testing, but the collection process.
Is that for both samples? Because there were 2 tests that
That's
this
right.
laboratory did on this gentleman.
Okay, the first sample that was taken wasn't actually sent off for testing. It was a bad sample in terms of they took the back hair sample off of him. They wasn't able to get any sort of reading on it. The next 2 tests we contend Psychmedics had involvement with because they had a laboratory representative that was there. And it's our position that on the tests that were actually sent off to be analyzed, Psychmedics had some sort of involvement with. But nevertheless, you know, those issues that may come up during the factual rendition of the case at trial, I think that regardless, you still end up with the same result here, whether they were involved directly or whether they were not involved directly, because the relationship between Psychmedics and the employees that are being tested is still the same for all practical purposes.
So
they made a mistake in...
If Psychmedics didn't do any badness, it's your view it's incumbent upon them to then bring in the employer for indemnification of some sort if the negligence occurred at the foot of the employer and not Psychmedics?
Well, I think that's where you have to parse it. If the employer did something negligent, they should be held accountable for it. But if Psychmedics was involved in the negligent, whether it's collection, I think you can hold liability for them there, but you can also hold liability for them in the actual testing.
Well, let me ask you one final question on parsing, because I know there'll be other questions in your limited time. You cited a series of cases where privity really doesn't matter.
Correct.
But we also have some jurisprudence where privity does matter. And I'm just looking for the framework that you're advancing that you think this court ought to adopt, because there are almost limitless number of situations where a party performs a contract knowing that non-contracting third parties will be affected by how that contract is performed. So where do we draw the line in going forward if we are to impose a duty here?
Yes, Your Honor, and thank you very much for that question. I think that we can look to the jurisprudence in Tennessee, Wyoming, Illinois, Pennsylvania, and I think that it's significant the test that was actually espoused in the Tennessee case, which dealt with this same defendant. And what the court looked at was whether or not, and it was a balancing act of the actual foreseeability along with the gravity of the harm and whether or not the defendant's conduct outweighs the burden upon the defendant to engage in alternative conduct that would have prevented the harm. The factors that this Tennessee court looked at was the foreseeable probability of the harm or injury occurring, the possible magnitude of the potential harm or injury, the importance or social value of the activity engaged in by the defendant, the usefulness of the conduct of the defendant, the feasibility of alternative, safer conduct, the relative costs and burdens associated with that conduct, and the relative usefulness of the safer conduct and relative safety of alternative conduct. And if I compare that case to the case that we have here, we believe, just like as in Webster, that Psychmedics is in the best position to guard against harm to foreseeable plaintiffs. They have a contractual relationship with the employer, and they are aware that these drug tests are being done to determine whether or not many of these employees are allowed to maintain their employment. Some of these employees, like in our case, are very long-standing employees of the company. They're devastated by the loss of their employment. The importance of social value of their actions is to maintain a safe workplace. This benefits not only Psychmedics, who's getting paid for it, but it benefits the employer, who has a safe environment. They're making cars, releasing them to the public. They have an obligation to ensure that these employees making these cars aren't under the influence of any drugs. And if you look at the risk, Psychmedics is in a better position to bear the risk than certainly any of our individual employees will. And that decision-making process is also reflected in Wyoming's decision. It's reflected in Illinois' decision. The Illinois case that we referenced, Stinson versus Physicians Immediate Care, talks about how the drug testing laboratory is the best position to guard against the injury. It's solely responsible for the performance in the testing and quality control procedures. The laboratory is paid to perform the test. They can bear that financial burden. And the Illinois court held that they owe the duty of reasonable care. significantly in the facts, I think it's very important to point this out to. Our client went back after getting the bad drug test from Psychmedics and got an independent drug test. BMW refused to look at that test because of their contract with Psychmedics. Were it not for their contract with Psychmedics, our client would have been vindicated. I think that's very important. That goes to the facts and it goes to the analysis that was brought up in these other jurisdictions.
Thank you very much, Mr. Wallace. We'll hear again from you in reply.
Thank you, Your Honor.
Will it be Mr. Nail? Yes, sir. All right, thank you, sir.
Good morning, Mr. Chief Justice, Your Honors, and may it please the Court. My name is Michael Nail. I have Matt Johnson here sitting with me to my right, and my firm represents the defendant in this matter, Psychomedics Corporation. As Justice Beatty stated earlier, let's cut to the chase. This is a very narrow question of law, and it's whether a drug testing laboratory owes a duty to an employee when that drug testing laboratory tests that employee's hair sample at the request of his...
And you would agree, wouldn't you, that a majority of courts have found a duty under these circumstances?
I would, Your Honor. I would agree with that. And
Not that we have to follow the majority. Many times, South Carolina finds its own path, but
yes,
that
Your
is
Honor.
the majority view.
Yes, Justice Hearn, we do recognize that. There is a split of jurisdictional authority, and that's why we're here today. And South Carolina has not addressed the issue. So what we can do is we can take this body of case law from other jurisdictions. We can synthesize the rules and information that those cases provide and then apply them to South Carolina law. And if you look at the Charleston dry cleaner and laundry case that we cited in our brief, that was a certified question to this court in 2003. And this court was faced with the question of whether or not an independent insurance adjuster, an adjusting company, owed a duty to an insured. In that case, the insured leapfrogged over the entity that they had a direct relationship with.
Who they could have sued in that case. And wasn't that a point made by this court? They did have an avenue of relief where the plaintiff here arguably does not.
It was, Your Honor, and I'm glad that you brought up that point. And the holding in that case was that there was no duty. And importantly in that case, this court recognized that in South Carolina, foreseeability of injury itself is not appropriate itself to impose a duty. There has to be something more.
The court quoted the Booz Allen case in that respect for that proposition that you just said.
Yes, Your Honor.
But when you read the Booz Allen case, Ports Authority against Booz Allen, it doesn't really say that. It says foreseeability of injury in the absence of a duty to prevent that injury is an insufficient basis. So I think the quote's just kind of been mashed together. But isn't that what the Booz Allen case says?
It does, Your Honor. I do actually...
So it still holds open the question of whether or not there's a duty. It doesn't say, as you said, foreseeability of an injury is not sufficient to create a duty.
Right.
It says foreseeability of injury is insufficient to create liability in the absence of a duty. So flesh those out for me.
Sure. And I actually think that foreseeability goes more to causation.
Obviously.
But foreseeability is something that these other courts that plaintiff has cited have addressed, and plaintiff actually bases his authority for a duty being imposed on foreseeability, and we don't think that that's proper. We think there has to be something more. South Carolina demands more. And to Justice Hearn's point of another avenue for relief, it is true that in that case, this court said, yes, there's a bad faith action against that insured. But it's important that you bring up this point, and I think it's important to make that plaintiff did have an avenue for relief here.
I think you're misunderstanding the significance of that. The fact that the plaintiff had an avenue of relief against the insurance company means that the employee or the plaintiff and the insurance company are adverse to each other. Before the fire, they're not, because they have a contract of insurance together. They do not have adverse interests. Once the fire occurs, and there's a question of the dry cleaners wants their customers paid, the insurance company wants to pay as little as possible, the relationship is adverse. To hold its position in that adverse relationship, the insurance company hires the adjuster. So the fact that they had an avenue of recovery doesn't mean like just because you can sue one person, you can't sue the other. It means that the fact that you can sue them means you're adverse to them. And we're never going to impose a duty of due care between two people who are adverse to each other. That's the basis of the dry cleaner case. And that's different from the case here. Because at least up until the point in time when the drug test comes back positive, certainly BMW and Mr. Shaw are not adverse to each other, are they?
No, Your Honor, not under your definition.
So are you saying that the avenue of recovery would be against the collector or BMW?
Your Honor, respectfully, the question is whether the testing company owes a duty, but I think it is important to address...
Who is the avenue of recovery? Against whom?
Your Honor, it could be against either one, potentially.
All right, would the collector come at that podium and say, under this body of case law, we don't have a duty, we don't have a connection with this employee? Wouldn't they be making the same argument you're making today?
They may, Your Honor, and frankly, if Psychmedics was the collector, which we say that they're not, and going back to Justice Kittredge's point from earlier...
Would you have a duty if you were the collector?
Not necessarily under South Carolina law.
So there is no avenue of recovery, in your view, against the collector?
The argument would be more strong if we were the collector, but...
Would you have a duty if you were the collector?
Your Honor...
It would be the exact same question. It's just you'd have a different person standing at a podium.
I don't think it would be the same question, respectfully, because if you look at the relationship, when I think of a relationship, as Mr. Wallace stated earlier, that's the basis of a duty. I think about contact and interaction. Psychmedics had no contact and interaction with this
Is that
employee.
necessary? I noticed you point that out more than once, but is that necessary?
Yes, it is, Your Honor. I believe it is.
There is no third-party avenue, if you will, of attack or a suit in a contractual situation where there's no privity?
Here, under a negligence cause of action, there's not.
General question.
Sure, and today, Your Honor, we're here to address whether there's a duty to impose a negligence cause of action, not any other cause of action or any other cause of action against another entity. But plaintiff did...
I'm not talking about a contractual breach of contract action. I'm talking about a third party being able to bring a negative action against another party, if you will, that's a party to this contract, although there's no privity. Are you saying that can't happen?
Your Honor,
I mean, that seems to be the basis of your no relationship argument.
no, Your Honor. Privity is different from relationship from our point of view. When you take a look at this body of case law, you're talking about contact and interaction. There's a reason that plaintiff in his brief, 3 out of the 4 cases that he cited from other jurisdictions involve whether a collector owed a duty. Because
so you're suggesting that if Psychmedics had sent an employee to collect the sample, we'd have a different duty analysis than if they sent a subcontractor to collect the sample?
that is correct, Your Honor.
Well, wouldn't that be that would be an analysis of the collector's negligence, duty and breach? It seems to me that's different analysis. That's why I said it a minute ago. I said it's the same question. The question that you were asked is, if the collector is standing at the podium, would you be arguing no duty? Of course you would, because the question here is there a duty of due care owed by someone who doesn't have a contractual relationship to the employee? And it makes no sense to me that the simple fact that you can hire a subcontractor to go and collect the sample insulates you from your negligence and changes the duty analysis.
The privity of contract, again, is separate from a relationship analysis.
Well,
Psychmedics isn't arguing...
Explain that relationship analysis for us.
Sure. Psychmedics isn't arguing that they're somehow insulated from a contract, and that's the reason that no duty is owed.
So your argument is that the relationship is too attenuated.
Correct, Your Honor.
Now explain that.
Sure. If you look at cases in other jurisdictions that talk about this issue, it comes down to 2 points: foreseeability and relationship.
You don't want to talk about the Hammond case, do you? I notice you showcase that case, federal case out of Pennsylvania in your brief, but that case is no longer good law. Hammond was a federal case that relied on a superior court, which is the intermediate appellate court in Pennsylvania, called Ney. Subsequently, the Supreme Court of Pennsylvania, which is the highest court, discredited Ney and found in Sharp versus St. Luke's Hospital in 2003 that there was a duty. So that case is no longer good law. What else have you got?
Correct, Your Honor. And in the Sharp case, that involved whether a collector owed a duty, not the tester. And in that case, the court said this individual presented to the collector. The collector knew what the purpose of the test was. That was that relationship, and there was a sufficient relationship there to impose a duty. Whereas
Psychmatic doesn't know what the purpose of their test was?
Your Honor, arguably
You're
not.
the one who brought that up. Of course they know the purpose of this test. That's absurd.
They probably advertise and say, we're here for you employers, we'll be good drug testers.
Well, Psychmatics has no control over how BMW uses that test. We
That
talked
doesn't
about.
say they didn't know why it was being used or how it was being used.
Well, Psychmatics has no idea. Mr. Wallace brought up earlier that they went no. Let me.
We might
That's
be old,
silly.
we're
So
not
let me
stupid.
clarify. So Mr. Wallace said earlier that plaintiff went out and got an independent drug test that BMW did not accept. Psychmatics has no control over how BMW uses this result, whether they suspend him, terminate him. They have no idea. They just simply test.
But they know that's the purpose of the test, the use of the test, to determine whether or not they're going to continue his employment.
Not necessarily, Your Honor, because many other things could happen. That's a suspension. They could put him under a rehabilitation.
Well, it would impact his employment.
Sure, that's
Okay,
fair. That's
and
fair.
you knew
Your Honor.
that,
That's fair.
and you knew that. Psychmatic knew that, right?
Arguably, yes, Your Honor. Yes.
No, arguably. I mean, come on, otherwise they wouldn't be in the business. But
I realize my time is
I
up.
want to ask you a question, if I may,
ahead.
Chief. The suggestion is made by you, and you've had several questions asked to you about this today, but is what if, I think Judge Kittredge's words, what if Psychmatic didn't have any badness? What if the real error here, assuming there was one, was not committed by Psychmatic, but was committed by the company that drew the sample? You suggest that's important, right?
Yes, Your Honor.
Okay, so wouldn't it be true, though, that the answer to that question is that when this case goes to trial, the plaintiff would lose because they failed to prove a breach of duty or they failed to prove causation?
That is correct, Your
So
Honor.
that really doesn't have anything to do with the existence of duty, does it? Or if it does, tell me why, because I don't understand why.
Well, breach is separate from a relationship aspect. So I think
I know that.
I understand what you're talking about.
You can't. If you have two people who either one of whom could have committed the negligence, the breach of duty, assuming both of them have a duty. The result, the way that plays out in a case is that one of them wins and one of them loses. It doesn't go back to you don't take it back to the existence or non-existence of duty simply because one might have been negligent and one might not have been. That's my question.
But you still have to determine whether a duty exists in the first place.
Right, but you don't analyze who was negligent in determining who has a duty. And your argument says that.
We're not arguing who is negligent. We're arguing who had the most contact, the most interaction, the most control.
You're not sure what you're arguing, to tell you the truth.
I would, Your Honor, I respectfully disagree based on the cases that we've cited in our briefs and in the law before this court under Charleston Dry Cleaners. We believe that foreseeability is not enough, as the plaintiff has suggested. If we're creating new rights and remedies here, also this, Your Honors, respectfully, this might be more of a legislative function. And for all these reasons, Your Honors, I would respectfully request that this court answer the question as no.
Chief, I'm going to go out on a limb. Can I ask one more question?
no, please. Thank you very much, sir. Mr. Wallace, in reply, please.
Thank
I'm
you.
going to ask you my question.
No, well,
Is there a difference between Psychmatic being hired by BMW to conduct this drug testing in order to promote safety at the BMW plant from perhaps BMW hiring a limousine company to drive Mr. Shaw to the airport so he could fly to Berlin to take a safety class at BMW's home office?
But the same place, there's still a duty there. Once you have
So the limousine company, nobody would stand up there and contend that the limousine company has no duty of care to the driver, to the passenger, simply because BMW contracted with them. And nobody would contend that because the purpose of the trip is safety at the BMW plant, that somehow mitigates or changes the duty analysis that the limousine company would have.
It has no change.
And even if the limousine company were to contract out to a maintenance company to take care of their tires on their limousine fleet, so now the maintenance company is 2 contracts removed from the employee, nobody would argue that maintenance company has no duty of due care to the person who's being driven to the airport to fly to Berlin for the purpose of improving safety in the BMW plant, would they?
No, Your Honor.
But under that analogy, the BMW employee is not going to lose his job, so that part
He's
of the
going to be
analogy.
dead if they have a wreck.
Let me ask you this question, please, Mr. Wallace. How do you get past the blanket statement that the defendant cites in its brief that foreseeability is an insufficient basis for recognizing a duty? That
yes.
plain sentence.
Yes, Your Honor, and we're not claiming that foreseeability is the end-all, be-all of our basis for recognizing the duty. Our rationale for recognizing the duty deals with the relationship between the parties as articulated in the Pennsylvania case, the Wyoming case, the Tennessee case.
All right, accept their factual scenario as true, that some unknown company, unknown to us anyway, plucks the hair with the tweezers. Doesn't have anything to do with Psychmedics. Puts it in the sealed package and does everything it's supposed to do and sends it off to wherever Psychmedics is. They open the package and they test it, and it comes back positive for cocaine.
You would then look at where the breach occurred of the duty.
Well, what if that person who plucked the hair just totally did it wrong and packaged it wrong and intermingled it with other pieces, parts, or whatever, and just came back bad? Obviously, Psychmedics is not responsible for that. Do you agree with that?
It does not. They wouldn't have breached. It doesn't change the analysis that they have a duty, but they would not have breached that duty because somebody else would have been there.
All right. So, how do you get past the statement foreseeability is not sufficient to create a duty? Foreseeability of injury is not sufficient to create a duty.
I agree. Foreseeability by itself isn't, but the relationship between Psychmedics and the employee that is tested and the employer creates that relationship.
There is some type of relationship.
There is definitely a relationship. As a matter of fact,
May I follow up with your the foreseeability of injury is part of the analysis.
it's part of it.
What you're focused on is foreseeability that the particular defendant might cause the injury.
That's correct. That's correct. And I want to point out, going to what Justice Hearn brought out, that case in Pennsylvania, the Sharp versus St. Luke's Hospital case, because it has some language in it which I believe directly addresses these questions that you're raising here. One of the things, and they essentially, it was a similar case, employee fired due to a positive test result, which was erroneous. But what the court said here, and getting to the issue of duty, Sharp personally presented herself to the hospital, who was aware of the purpose of the urine screening. The hospital, in turn, should have realized that any negligence with respect to the handling of the specimen could harm Sharp's employment. That's what we have here. We've got a drug testing company that's contracted with BMW, knowing that the results of that drug test company will affect the employees.
Back to Chief Justice Beatty's question at the end of Mr. Nell's argument, that what happened with whether the collector was part of Psychmedics or not, you go back to the relationship between Psychmedics and BMW, and the purpose of that relationship has meaning only in terms of how an employer will respond to an employee as a result of those test results done in reliance on the accuracy of what Psychmedics does. Is that correct?
That is correct, Your Honor. Psychmedics is aware of the relationship between BMW and themselves and how it's going to impact the employees. Knowing that, I think when you look at the relationship between them all, it gives rise to duty. They couldn't come into this state and put these employees' jobs and jeopardies at risk based on their testing, and then try to hide behind the fact and say, oh, no, we don't have a duty. You deal with that with your employer. But you're the one that put these employees in that situation. And these are devastating results for employees. I think that Tennessee citizens deserve no less protection than South Carolina citizens in this regard. And they dealt directly with this same company doing this exact same thing. And I think the analysis in that case, along with the Sharp case, which overturned the case cited by the defendant, along with the other cases that we cited, give a clear analysis of the relationship between these out-of-state drug testing companies and the employers that they work for, and how that pertains to the relationship with the employees and affects the employees, Your Honor.
Thank you very much. We'll be in recess.
Thank you, Your Honor.